In this module, we begin to shift gears away from looking at what's right from an ethical perspective to looking at what's right from a legal perspective. The first thing we're going to do is spend a bit of time looking at the legal system in Australia. Now, this means that there's a huge disparity across the student body about the level of baseline knowledge of our system for a number of reasons. One, it depends what you're studying here at uni. So some students are studying law, so they've got a pretty good understanding of everything that we'll do today, I think. Second, if you've been educated in Australia, you've probably dealt with some of these topics. You might not remember it, but I know, for instance, we deal with our parliament in about grade 7 of primary school. So you've probably dealt with it, but you might not remember it. Third, we've got your personal interests. Some people really keep up to date with what's going on in government, etc. I know not many, but there are some. So they're going to know a lot of this as well. And then finally, obviously, if you're an international student, even a number of the core ideas here might be a bit confusing because the legal system back in your country might be entirely different. So that means this week is probably the most difficult in terms of content to deliver. There's a lot of content because to make sure everyone from an international student who has no understanding of the history or legal system of Australia right through to, say, a law student who studied it in detail, man, there's an enormous amount of content there. I don't expect you to learn all of this, but I think it's important that you understand where things come from and why they work the way that they do. We don't directly test any of this content, but if you don't understand it, understanding the content as we move forward in the subject becomes harder and harder. If you don't understand the common law system, the doctrine of precedent, all of those things, the intersection between judge-made law and legislation, it becomes difficult to understand why the law is what it is and how it actually operates. Anyway, hopefully what I've just said there will make more sense as we go through this content. Obviously, you should feel free to skip the little videos for areas that you're across and maybe even just skim read the notes to make sure that you understand what we're trying to emphasise in this particular subject. But with no further ado, why don't we get into some of that actual content? So there is a lot of content, and we've really got to start at a base level by understanding what law is and its relationship to business in society. Once we get this idea of what law is, as opposed to, say, ethics or strategy, we can then start thinking about the specifics of the Australian legal system and the very basics, the 6 hallmarks of our system and how it has developed over time. The next thing we're going to do is to look at federation and the Constitution. And the reason we do that is because we have 2 levels of government in Australia. So that gives you an understanding of which government deals with which area of law. Some people may not even have thought of that at this point in time, and hopefully this will give you an insight into how that's determined. So as well as looking at those 2 levels of government, we look at the arms of government. So we look at the difference between the legislature, the people who make the laws, the executive, those who administer it, and the judiciary, those who apply it or make decisions. So we need to understand how those 3 arms of government work to understand how law works. And then we try and finalise everything with this introduction and very brief look at statutory interpretation. Why is that important? Well, okay, so we know that a lot of the times Parliament is actually going to write the law and make a law, but the real problem arises when that law has to be applied and someone has to interpret what they said. And so we're going to get a bit of a handle on that. And in so doing, we get this understanding of the relationship between Parliament-made laws, statutes, acts, and judge-made law, precedent. And we do that through that issue of statutory interpretation as well. So that's an awful lot of content, but hopefully we'll come away with an understanding of those basic building blocks of the Australian legal system. Okay, to put it into a diagram, Three key things. First key thing, what is law? Second key thing, the principles and the main ideas behind Australia's legal system. Third key thing, how law is actually made in Australia. So our starting point is to look at what we mean by law. What is law? So you may have heard terms like, rugby union was a classic, that they have the laws of the game. So are they laws? Are the rules in rugby a law? No. And we often have lots of situations where there are rules. You can have rules at QUT, your lecturer or tutor could have rules about how they run the class. There are rules in games, but they're not the same as law. So we have to think about that distinction between rules and law. So law is a set of rules, but they're a set of rules made by the state. So there's a government involved. Notice we use the word state because the state can take many different forms. There are many different forms of government. So they're the set of rules made by the state and that they're enforceable, right? They're enforced by prosecution or litigation. Now, I've said throughout the course that words are important. We use two different terms that may sound the same to someone not familiar with legal terminology: prosecution and litigation. Now, they can be used in everyday life to kind of mean the same thing, and they are used somewhat interchangeably, but when we're using them here, prosecution is where the state enforces the rule. The government is enforcing it against the citizen, whereas litigation is where the citizen is enforcing it against another citizen. So they mean two different things. It is about the enforcement of a rule made by the state, but is it the state enforcing it on the individual, or is it individual enforcing it on another individual? Okay, let's go to a classic example. Criminal law is the state enforcing the criminal laws against the citizen. So it's prosecution. When you breach a contract with me, it's me enforcing my contractual right, a rule made by the state, against you, citizen on citizen, and I would litigate that. That is litigation. That's an example of the difference in the use of that terminology. And for the purposes of what we're dealing with, business law, they're the set of rules regulating businesses and business activities that are made by the state and enforceable by prosecution or litigation. So there are some things that are enforced by prosecution. There are, in fact, some crimes involved in running companies, for instance. And then most of the time it's going to be litigation. It's going to be one private citizen trying to enforce rights against the other. Set of rules made by the state, enforceable by prosecution or litigation. Now, I'm sure you're aware that law has a number of purposes, a number of benefits as to why we have the legal system and something we'll come to called the rule of law. So what are the benefits that come from a legal system? Well, the first thing that happens is it helps you resolve disputes. And so an example of that in business is contract law. What happens if you're not sure about a deal that you've made? Well, if there's a dispute about it, we have contract law to resolve that. It can maintain social order. We need taxation to do that, right? Often in taxation, it will be the state involved because it's the state that imposes taxation on the citizens. It can preserve and enforce community values. So, for instance, there's differing work health and safety standards between countries. These vary highly between countries. And so what you see is this law, work health and safety, is a reflection of how much a community values the safety and health of individuals. So the community values of safety gets turned into a law or requirements around that. Law is often used to protect disadvantage. So legally, in business, we have anti-discrimination legislation in many forms. We have industrial relations to bring some stability to the economy, telling us what the various parties like unions and businesses can actually do when they're negotiating, particularly large ones that could disrupt society. So we have industrial relations law. And finally, we have laws that prevent the misuse of power. Consumer law is a classic example of that. Within the Consumer Act, we also have anti-monopoly provisions. So there's a whole lot of benefits that come from having a legal system and a set of laws rather than just a free-for-all. Now, you can probably remember that in Module 1, we distinguished the difference between law and what's ethical. So there's a difference between what the law is and what justice might actually be, or what is morally right in any circumstance. Ideally, we want a big overlap, as big as possible, but we don't mean the same things when we're talking about law and principles of ethics like justice. Having said that, I think it's really important to understand the different philosophical positions that people can take around law and, for instance, whether or not you should break the law. In a very simplified way, we can think about two kinds of scholars, just like you might have two kinds of approaches to ethics involved in relativism. The first set of scholars, and people can adopt this position or hold this position without even knowing it, are natural lawyers. So natural lawyers believe that there is something independent of humans making the law that makes a law right. They believe that natural reason or a divine force is behind the correct or the right laws. This is a tradition that comes from Plato, Aristotle, picked up by Thomas Aquinas. Right? You got a whole tradition, particularly in the Western sphere, that is based on this idea of natural law. And this approach is an unstated belief, it's underpinning human rights, for instance, that there are good laws and bad laws. That the good laws are those that are aligned with this sense of reason or some divine source. And therefore, there's a big question mark about what we should do when faced with a law that doesn't align with what we perceive as natural law. This is similar to the moral absolutist from week 1. In contrast, positivists say the law is what the state imposes on the citizen, and that's it. There's no such thing as a bad law or a law that deviates from what it should be. The law is whatever the state makes the law. So this approach is quite secular, and it also concentrates on what is, on what the law is, rather than any sense of what the law should be. So therefore, this approach wouldn't naturally lend itself to you breaking the law, whereas a natural lawyer might say, well, this is the bad law and I shouldn't follow it because it's out of alignment. Here, they're saying the law is what the law is. So breaking it has a very different implication. And in this sense, law is far more based upon power than any sense of justice. We start to see this growing distinction between the idea of law and ethics. Now, while there may be some disagreement as to whether law should align with a natural set of laws that come from logic or a divine source, or whether law is just what it is, both those camps would agree that whatever the philosophical background, there are some dimensions or some hallmarks of good law. Good law is certain. It's not easy to follow a law that's ambiguous or unclear. For a law to be a good law, you have to be certain about what the law is. Having said that you need to be certain about what the law is, good law is also flexible. Situations change. A classic case is technology. If you make a law based upon static technology, it will soon become unfit for purpose, well, at least in certain specific contexts. So one of the areas that the law has struggled with, for instance, is copyright. So it was based upon a technology and a way people worked. And today there are all these ways that we copy and use text, and AI is a classic example. Do people have the right to upload material into AI, etc.? So when the original ideas around copyright and IP are formulated, they often don't foresee the uses that are going to occur later. And we get into some situations where it doesn't really fit. A good law will be flexible enough to change and adapt to those changing contexts. And it's not just in technology, societal standards change, expectations change. So there's a lot of areas where there's a lot of change in human society, and laws need to be flexible enough to change with that. The third thing we need is that we need law to be accessible. Now, there's no point in having laws if people can't access it to work out what it is. The law could be certain, but if you can't find it, you can't follow it. So you have to be able to find out what the law is. Ideally, enforcing your rights under the law will also be accessible. So accessibility means a couple of different things. But if the citizen can't access laws, then it's not a good law, either accessing it to know what it is or accessing it to enforce their specific rights and the obligations of others. Finally, a good law will be fair. It will lead to just outcomes. So we can see that this idea of ethics, or what is right, this idea of fairness, which in itself is contested, something we'll get to in week 11, but fairness does form a dimension of a good law, but only one. Good laws need to be certain, flexible, accessible, and fair. Okay, I think that overview of law and what it is and what a good law is probably enough to get us started. In the next video, we're going to look at some of the attributes of systems of laws and Australia's legal system.